Hello, everyone. Welcome to this webinar about licensing design. Let's just check that yes, we have video working and hopefully sound too. Just a couple housekeeping things before we get started on the subject matter today. So this webinar today is recorded. So in case you do not wish to be seen or heard on the recording, then please just keep your video and mic off during the whole webinar session. But otherwise, we will have time for discussion and questions at the end part of this webinar. Another thing is that we were supposed to have two speakers today, but unfortunately, our guest speaker was unable to come today. So it will be just me speaking today. But I think those are all the housekeeping matters for today. And in case there's any technical issues, please just put those in the chat. And also any questions, comments you have during the presentation, you're welcome to ask those in the chat as well. And as mentioned, we will have free discussion at the latter part of the presentation. But yes, let's change this. Right.
Painetaan näin.
Yes, so good. Now I think we should have the presentation. Yes. Yes, so now we're sharing the correct screen. So let's jump right into the subject matter of today. So today we're discussing licensing, and especially in relation to design. However, licensing is a very versatile legal tool, and it will apply to other forms of intangible assets as well. Before we get to the actual licensing questions, I will just quickly discuss a little bit about who I am. I am Iiris Adenius. I work at Ornamo Art and Design Finland. I'm a lawyer and an economist, and I've mostly worked on intangible matters and advising designers during my career. And as mentioned, I work for Ornamo, and Ornamo is a design association in Finland, and we represent about 3,000 individual members in all fields of different designs. And we're able to have this webinar series this autumn, concentrating on designers' intellectual property questions, because we are currently collaborating with BEDA, the Bureau of European Design Associations, which is an European umbrella organization for design associations and design promotion organizations throughout Europe. And we are currently collaborating on this joint project that aims at empowering designers and small and medium-sized enterprises to utilize the full potential of their creative and innovative work with the help of intellectual property rights. And the project name is Design as a Competitive Edge, and we're focusing on intellectual property rights for designers. And this project has 4 webinars during this autumn that are available for everyone. And we had the first one a couple of weeks ago, and the recording of that webinar is also available, and we can post a link to that webinar on the chat. So even if you missed it last time, you can find that in our YouTube channel. And also in 2 weeks we will have a webinar that concentrates on battling IP infringements in an online environment. And then last, in the beginning of November, we will discuss a little bit of the new design legislation that's upcoming, and especially how that will affect designers' work. But yes, just to quickly, a few words about designers' intellectual property rights on a general level. We discussed these in more detail last time, especially from the point of view of design protection. But just as a very short intro to this matter before we jump into the license agreements. So intellectual property rights can be divided into two main categories. One of them is copyright, and the other part is industrial rights. And industrial rights include many different rights. For example, designs, trademarks, and patents. And so this is important to remember, that when we're talking about intellectual property rights, it's a broad term that includes many different kind of rights. Typically, it's good to use this general term, intellectual property rights, unless you really want to focus into just one specific type of right. Oftentimes, people discuss or use copyright almost as a synonym for intellectual property rights. So it's just good to remember that that is actually just one side of intellectual property rights, and the broader term also includes industrial rights. And this is also something we discussed last time a little bit. So one design product, so in this example, a light fixture, can be protected with different type of intellectual property rights. So with a trademark, design, copyright, or patent or utility model, for example. Also other options are available, but this is good to remember. And these different type of intellectual property protection forms, they have different requirements on how to achieve them, how long they are valid, and what is required to obtain those rights. And also another small reminder that intellectual property rights are based on legislation, and typically that legislation grants the right owner some rights, which are most often exclusive rights that allow exclusive use or exclusive commercial use. And in practice, that means that the right owner has the right to prohibit. So that means that the right owner is expected to be active in monitoring and enforcing their own rights. And this is why it's really important for designers and all companies and people working, especially utilizing intangible assets such as design, to understand intellectual property rights, at least on a general level, because this is the legislation that actually gives tools for designers and right owners to protect and safeguard their own rights. As part of this project, we have made a little introductory video to intellectual property rights, which you can find on Ornamo's YouTube channel. And additionally, all the project material is available at Ornamo's webpage at ornamo.fi, and also at BEDA's webpage, beda.org. So you can go to those web pages and channels to find these this information. And especially this short introductory video is good if intellectual property rights are a somewhat new subject, or if you just want to kind of be reminded of these questions. And this is also something we discussed a little bit last time. So again, this is an overly simplified picture of a design process where a designer first has an idea and a concept for a product or service, and that idea and concept gets a specific expression, which in this case is a model for a light fixture. And then when that light fixture is made into a tangible product that can be sold to customers. And where do we need intellectual property rights? Well, especially from the customer's point of view, there might be very many similar category products in the market. So the customer might not be able to identify or know where do these products come from, who's behind these, who has designed which product, and so intellectual property rights are actually a way to help the customer to identify the source of these different products. And of course, from the designer's perspective, intellectual property rights allow the designer to prohibit somebody else to bring to market or make products that are similar to theirs, in case they have taken care of the required registrations, for example, to get these rights. Well, how does license relate to these questions then? Well, as soon as we give somebody else a right to do anything with the model in this case. So, for example, we'll have somebody else manufacture this model into the actual tangible products that are being sold. The manufacturing contract in itself has a license piece in it. Typically, it is said in the manufacturing agreement, but even if it's not explicitly mentioned, it is implicitly understood that the manufacturing agreement includes this type of licensing piece. And the same goes for giving somebody else the right to resell products in different markets, for example. And then kind of the most common situation when it comes to licensing design is the situation where a designer grants typically a company, a customer, the right to manufacture and sell, for example, products that are utilizing this model. And this is I would say the typical situation that will be the base of today's examples as well. We will discuss other situations too, but this is the typical situation when it comes to licensing design. Now, another option for licensing is an IP transfer, where actually the customer gets all rights, and let's discuss that option as comparison to licensing a little bit later. But it's also good to remember that many times, especially the customers would like to get these exclusive rights, but it's good to remember that license is actually a very great tool that allows for the same model, for example, to be licensed to several different actors, for example, in different countries. And of course, licensing is a very versatile, powerful tool that is not restricted to just, in this example, tangible products, but of course, intangible products as well. And a typical example of a license agreement is, for example, a terms of use in a software program or application, for example. And everybody taking part on this webinar today have already signed many license agreements, regardless of how conscious they are of this. But most of the user terms that we click online, without taking too much time to look into the terms, they typically are licensing terms, or at least have that piece as part of those terms. And here's another type of example of a licensing situation. So in this case, this could be, for example, a consultancy type of situation where the designer offers consultancy services to a customer, and the customer will get as an end result, for example, on application or report, and this end result that is offered to the customer can have different parts in it. So there can be non-exclusive license granted, which can be these kind of general, for example, general training sessions and a general software piece, for example. And then there can be customer-specific parts, customer-specific application, customer-specific report that can be given an exclusive license. And then it's also important to remember that many times also the customer might actually grant the designer a license to use some of the information that's organization specific in order for the designer to provide these services. So one project can very easily contain multiple different licenses with their own license terms. And what a license is, in very simple terms, license is an explicit permission that allows access or use. And again, this can be license is typically used for intangible property, but that intangible property can of course become tangible, like in this example of a light fixture. But the piece in itself is intangible, and if it was tangible, we would use a different term to allow access or use. This is also kind of like a good way to compare what does license mean. So if we were talking about tangible products, we would typically be discussing about a lease contract, for example, that allows somebody else than the owner to use a specific property. And a license typically sets out the conditions for that access or use. The same way as in, for example, in this like leasing contract, the leasing agreement in itself would also set out those conditions. All right, so let's continue with this very simplified version of licensing design. So a very typical situation that I have seen in advising designers is a situation where a designer has designed a model, and at this point, before the right customer is found for the model, there's kind of two options. That model can be registered, or then it is very important to keep that design confidential and utilizing a non-disclosure agreement for that purpose. And after that, it's kind of safe from the legal perspective, or safer from the legal perspective, to find a customer. And then once that customer has been found, then that model can be licensed to the customer with a license agreement. And then based on the agreement, the designer receives a compensation, and then typically both the designer and the licensee will monitor and enforce intellectual property rights related to that model. Now, of course, another option that is also very typical is one where a customer actually hires the designer to design a specific model based on the customer's needs, and those situations, a license agreement is also a very useful model to use. Depending on the situation, in case the customer is hiring the designer, they might push stronger for an IP transfer agreement. But we will discuss the differences between those two options a bit later on. All right, so now we will go through a license agreement, and the point of this next part is to go over the most important parts of a license agreement. Like I mentioned, a license agreement is actually a very versatile tool. So of course there are many variations of a license agreement that we will not be able to discuss today. So we will just discuss a couple most typical situations from designers' perspective. But these same principles, of course, apply for licensing other intangible property, as mentioned. And the purpose here is to kind of go over section by section key aspects of different contractual parts. For example, in a situation where a designer either receives a license agreement template or is planning on drafting one, to have a good understanding of what do these different pieces actually mean, and what are the things that should be considered when drafting or going through a license agreement. So as with all agreements, a good agreement defines the rights and responsibilities of the parties and answers very basic questions. Who is doing what, when, and how? And this is something I like to emphasize with all contracts, is that it's always good to start with very basic level, very concrete level, and go through with the other party, or even just as one party, these very simple questions to make sure that both parties are actually on the same page of what is actually going to happen. Or for example, if you're a designer, you're planning on designing your design, you can go over these questions and make sure that these are incorporated in your offers that you make to your customers. And this might seem ridiculous how much time is spent on this very simple part, but this is typically something that I've seen in my career, that there can be a template for a very complicated license agreement, but actually when you ask these questions, the parties might not be able to answer those questions. So it's always good to remember that a contract is nothing more than what is actually agreed between the two parties. So start from the simple level, very non-legal language of what is going to happen between the two parties. And when these basic things, who, what, when, and how have been established. Of course, it's always important in a contract to know what is the compensation, what's the payment part of a contract. Most typically there is one. However, it's not an absolute requirement. There can of course be agreements that don't have at least a monetary compensation as part of the contract. But typically in a license agreement there is one. The other part that's good to check that your contract can answer is whose responsibility it is to do what. So even in some cases it can be that, for example, it is in a design agreement, for example, that the designer actually designs a product, but what is actually the responsibility? So typically the responsibility is based on prompts that the customer gives the designer, and so the responsibility is not always the same one who is kind of actually carrying out the work. And then what to do if things go wrong. So what possible ways can things go wrong, and how should those situations be rectified? And this is also something that is really important to discuss and go through in advance, not at the situation where things have already gone wrong. So it is a much better negotiation situation to discuss these different options as a hypothetical one, and not as a concrete thing that has already happened. Yes. And here is a couple typical headings that many license agreements have. Again, not all, and not necessarily everything is found in all license agreements, but these are typical headings in license agreements, and now we will go over most of these headings in a license agreement. But before we start in the content, a couple words about names of a contract. So this is also a question that I've gotten many times: is that is the license agreements, do you have to call it a license agreement, or can the title, the name of the contract, be something different? And the answer there is yes, it can. Of course, the name of the agreement has some communication purpose and meaning, so it's not a totally meaningless matter, but typically you shouldn't pay too much attention to this. So many different contracts with many different names, again, at least have that licensing piece built into that contract. And here are a couple typical contract names that will have that either are predominantly licensing agreements or have a strong emphasis on the license terms within the agreement. Yeah. So let's jump into the first part of the contract. So this is typically the very first part in any contract, not just license contract, but just defining who are the parties. And again, this is something that's many times just kind of very quickly people go through this and just assume that this is correct information. But this is also a place that's good to spend a little bit of time thinking, okay, do we actually know who these different parties are? Couple terms So in a license agreements, there's typically mentioned a licensor and a licensee. And the licensor is the person who gives the license, and the licensee is the person who receives a license. And these terms are unfortunately close to each other, and many times, if these two terms are used in the license agreements, I would say many times, I can't really give a percentage, but many times there is at least one place where those have actually been mixed up in the contract. So it's good to pay attention to this. I personally like to use something else for at least one of the parties. So, for example, using designer instead of the licensor, and then having the licensee as the licensee, or sometimes you can even use just the names of the companies or the people who are parties of the contract throughout the contract. So it's easier to keep track who is actually doing what and is responsible for what. And of course, when you're going through the responsibilities and rights of each party, it's very crucial that those terms are correct in the contract. A couple other things to consider. So it's good to consider if the licensor is an individual or a company. In terms of design companies, there can be situations where it is actually the designer as a natural person who might be the right owner, and they could be the direct licensor to the customer, or sometimes they can have their own company that's actually the first licensee of the design, and then their company is in that sense a sub-licensor to the customer. So it's just good to keep in mind who is actually the right owner, and always good to check that the licensor has the right to grant the license. That's the object of the license agreement, and of course this is a bit more complex issue. There can be, for example, some kind of cooperation that has created the design, and so it's important to make sure that a single entity either fully owns the design as a whole, or then everybody who is a right owner to the design is mentioned as a licensor. And also, it's good to understand who the licensee is, if it's a single entity or if it's actually a group, and within the group there's a need for a wider license. So actually, the licensee might consist of several different companies. Yeah, and so it's just good to pause at the parties section already and make sure that the information is actually correct there. And then the second part of the contract is typically the purpose and scope of the contract. Here there's a lot of variety how this section is written out, but it can easily just give a little bit of context. So it's good to kind of understand that if an outsider reads this section, do they understand what's happening? There might be some background that it's important to understand from the point of view of the further contract. So this can be a place that can explain a little bit of background. But again, this I would always lean towards clear, not too jargony language here. So just making sure that it's written in an understandable form. What's happening? Who's doing what? What's the purpose? What are we trying to obtain with this contract? And this can many times also have can affect the interpretation of the rest of the contract. So again, I've seen many contracts where I cannot tell from the contract or this part what is actually happening, who is doing what. So again, this is a good place to pause and check that this part makes sense. And again, it kind of many times already is mentioned in this part that what is it actually that is being licensed here, and so what is kind of the object of the license? Is it an end result? So it can be a model, a report, a brand, a pattern, for example, or it could be a specific method, like a manufacturing method, or a tool, or a program, like we discussed that many times these software applications are licensed through these terms of use. Or of course, it can be a combination of these different ones. Another typical situation is that there is it is just mentioned here that the licensor is licensing a model to the licensee, and the model is further defined in a separate annex. Now, this is totally fine. This is one option to define the object of the license. But again, I have seen couple situations where the annex was actually forgotten. And so again, in the situation that something happens later on, we have to try to figure out what did the parties actually mean by this, because the contract in itself doesn't actually mention what is licensed here. And so we have to rely on kind of empirical evidence that what it most likely was. So it's just good to remember that if you put any annexes, but especially kind of just referring as the main context of the contract is defined under an annex or an attachment, to remember to actually attach it to the contract. And as mentioned earlier, same contract can have several licenses. So this is also good to mention at this beginning part of the contract to kind of clarify again to the parties themselves, of course, first and foremost, but also to a third party who might be reading this later on, that what is actually happening here, what kind of rights are being licensed by who to who. And again, sometimes these terms, who is the licensor, who is the licensee, can switch in the contract. And again, then it's especially important to remember these terms. Are they used consistently, and do they always mean the same person? So it's good to check these with care. All right. So content of the license. So the grant of license is from the point of view of a license agreement, the most important part. So again, this is again the place to spend most amount of time and resources to really think through what is happening under this contract. So when we think about these simple questions that the contract is supposed to answer, many times quite complex decisions actually have to be made in order to answer those questions properly. So first, there's the question of what is being licensed. So the object of the contract, and as mentioned in the previous slide, this can be an end result or a method combination thereof, and again, many different forms of intangible assets can be licensed. And then, what is the actual license? So what does the license allow? What kind of use does it allow? And here is a list of couple typical examples of what contracts, how they determine this what question. And here there are a couple examples, for example, right to manufacture, right to sell, offer for sale, market, import, export, or in case we're talking about services, the grant of license can be the right to use the services in accordance with terms of use. So there's more specific conditions on how to use the services, right to exploit for private use, for example, right to display something, right to use internal activities. These are typical examples in license agreements. And then there's the question of when. So what is the term of the license and the validity period of the license? And of course, there are many options here. It can be determined to be valid for a fixed term indefinitely, and then in some cases the license might even be irrevocable, so it cannot be cancelled or terminated, at least maybe cancelled in terms of breaking or breaching conditions, but not at least a normal termination applies. But let's discuss that further as well. But this is an important question to answer with the license agreement. And then where? So this is the geographical definition. And where is the license valid? So this can be defined in very specific regions, areas, but most typically in terms of countries. And then there's the how question, and this can be a qualitative definition. So this can, for example, relate to material decisions, using specific manufacturing terms, certain sustainability conditions can be set out as the qualitative definitions for the license. So here there's a huge variety on the question how. And I've included here a couple examples of license terms and contracts that I have seen, and these are real life examples where just have been made anonymous for purpose of using these in this kind of context, but a typical example of a license term in an agreement is, for example, that in the purpose section, it's defined that the purpose of the agreement is to agree on licenses, right to use licensor's model. And again, in this example, it's defined in an appendix, and it just very simply says here in its business activities. And then the license is further determined to say that under this agreement, licensor grants licensee a non-exclusive license to use the model in its business. And again, here is a list of countries where the license is valid. And during the term, that's also determined in the contract. And that the license is granted for the specific purpose of manufacturing, marketing, and selling goods in this territory. And then it says here that it's a non-exclusive license, and then it also here kind of again states that the license does not limit the licensor's right to use the model or license the model to third parties. And another example of a license here in relation to brand, for example. So a designer could also, as a part of a broader license agreement, or just on its own, license its brand to another customer. And again, here there are a couple of terms here. So in this example, the licensor grants licensee a non-exclusive, non-transferable, and revocable license to use its brand name, trademark, logo, and associated brand elements. And then there's strictly in connection with marketing, distribution, and sale of licenses, products, and services. And again, there's other terms for the use. And for later on, it also lists specific product categories and services that the brand can be used in association with. So a couple examples from license agreements. And now we already saw a couple of these terms. So these are some of the most common terms used in license agreements, which many times I've gotten the question, what do these all different terms actually mean, and how do I decide which term do I use in this license agreement? Many templates, also Ornamo's template for a license agreement kind of has these as options that then the designer can choose from. So let's go over these most common terms that qualify the license. So exclusive or non-exclusive. This is one of the most important questions in a license, and we will discuss this further, since this is very important question, and also can be a quite complicated question as well. But in very simplified terms, an exclusive license is only given to one customer, and a non-exclusive license can be given to several customers. Now, the kind of most simple example is where one customer gets all of the rights everywhere globally for a very long time, and so nobody else is granted any rights when it comes to this model, for example. But the exclusivity should be determined in the contract. So let's say, for example, we can give one customer the exclusive right to in this previous example of a light fixture, to manufacture and sell, offer for markets this light fixture in one country or in couple countries, and give another customer the exclusive right in another geographical area. So both customers will get the exclusive license, the exclusive right, but it is geographically defined. Where does this exclusivity, where is it valid? So in that sense, the exclusiveness is not absolute in that sense, that nobody else has the same right, but nobody else has that same right in that same territory. And of course, time is another example. We can give somebody an exclusive right for a fixed term, and we can give that same right to another customer after that time has passed. But we'll get back to this question later on. The other question is whether the right is transferable or non-transferable. Typically, in contracts, it does state that it is non-transferable, and often with the exception of, for example, selling the whole company. So if the whole company that's the licensee in this situation is, for example, sold to another company, they would get to keep the license under those circumstances. So it would be legally transferred to the new owner, but no other transfer would be allowed. So that's kind of very typical situation. Sub-licensable or non-sub-licensable. Again, huge variations based on what kind of intangible asset are we discussing here. Sometimes it absolutely is the purpose of the contract that the licensee can then actually utilize this license in their own work that they're selling to other parties, and they might be licensing this design in this example, for example, and in other situations, it's very clearly non-sublicensable. One example of a typical situation where sublicensing is allowed is, for example, this group situation. So a license is licensed to a group, and within the group, this license can be sublicensed, but only to these daughter companies, for example. And then the term of the contract, is it indefinite or fixed term? Indefinite doesn't mean forever. It just means that, for example, there is a termination clause that says that the licensor will have to give the licensee a 3-month notice, and then the license will be terminated. And a fixed term, of course, means that the term of the contract is predetermined. So we know at the time of signing, when does the license when does the term end? And revocable and irrevocable. So revocable means that it can be terminated, and irrevocable means that the license cannot be terminated. Again, one exception many times is if there is a breach of contract, then this wouldn't apply. And then last question here is the right to modify or make derivatives. So does the licensee actually have the right to make any changes to the design, for example, that they are licensing? So again, these questions should all be kind of considered in the context of the specific contract. But these are the typical questions that will need to be answered with a license agreement. And it's good to view this also in comparison to IP transfers. So on one hand, if we have non-exclusive licenses that can be licensed to an indefinite amount of different customers, and on the other side of the spectrum, we have an IP transfer where all of the rights are transferred to one customer who now solely owns the design. We have the exclusive license in between, and how we determine the time, the territory, or specific use determines whether the exclusive license is closer to the non-exclusive or closer to the IP transfer. And this is why the exclusive aspect is often an important negotiation tool, because by utilizing these different qualifiers, we can bring the license closer to these two different ends of the spectrum. But we'll discuss that also in the latter part of this webinar. But just good to understand, and maybe good already at this point to mention a little bit as a negotiation tool that many times the customer will demand to get a full IP transfer, and so then the negotiation of the contract does come into, if the designer, for example, only wants to license the design, that how do we determine the exclusivity? Because with a license agreement, we can bring the license very, very close to a full IP transfer, with the exception, for example, if we talk about like the broadest possible exclusive licenses, is that essentially the customer has all the same rights as if they were the owner, but the difference is that, for example, when the customer, if they would go bankrupt or something would happen to their business, or they would in some other ways breach the contract, then the the license would no longer be valid, and all the rights would be now fully utilizable by the designer. But let's discuss these negotiation questions also a bit later. Here's also one example of an exclusive license in a contract where the licensor grants licensee an exclusive license to use the work, and again in this example it is left to be determined in a separate appendix, and then in accordance with terms and conditions in the license agreements. And the licensor grants the licensee the right to use, reproduce, incorporate, distribute, make available to the public the work and derivative works thereof for commercial and for other purposes. And then it states that the work may not be modified without the consent of the licensor, and the right of use may not be sub-licensed or transferred. And then it states where the license is valid. Now, again, there's a couple of things that's good to notice in this example. So here's again that the licensee is allowed to make derivative works, but is not allowed to modify the work. So of course, in this example, then the question kind of comes: what does this mean in practical terms? Have this license term, has it just been copied somewhere without a real consideration of its meaning, or if it is actually considered and there's an idea behind it, what can the licensee do and what cannot they do? It's very good to, again, in very clear terms, determine what does that mean. All right, so let's talk a little bit again about this difference between an exclusive and non-exclusive license. And again, as mentioned earlier, this is a very, very powerful negotiation tool. And first of all, it's good to kind of start with the question of whether the exclusive license is necessary. And again, a typical negotiation it goes such that the customer would like to get a very broad exclusive license, but then it's good to understand if the customer's market reach actually justifies the exclusivity. So in case the customer only has activities in North Europe or in a couple countries in South America, for example, is a global exclusive license really justified? And so these questions are good to answer. As a general rule, it's good not to grant any licenses that most likely are not being used. So if it's not actually used globally, then especially when it comes to exclusivity, it's better to possibly give a non-exclusive right globally and then exclusivity in specific regions that the customer is actually actively in business. And then, of course, the important question is whether the compensation is proportionate to the license granted. So an exclusive license, of course, means from the designer's point of view in this example, or any licensor's point of view, is that they cannot give that same license to any other customers within those same terms, so in those same region or same use, for example. So of course, the compensation that's being paid by the licensee to the licensor should be proportionate. And again, these are the great questions to ask, especially in relation to exclusivity. What is the duration of the exclusivity? In which territory is it valid? And is there a field of use restriction for the exclusivity? So what does the field of use restriction mean? Well, this could be, for example, manufacturing a product utilizing one set of materials and another using different type of materials, for example, or a pattern could be only granted exclusively to somebody who will make a fabric out of it, but the same pattern could be used in a different product. And again, the exclusivity would just be restricted to that specific product, so that specific use. And then this is also a very important question then, who is in charge of the intellectual property rights and who is liable for IP infringements, for example. We will discuss this further again, but again, this is good to understand from the point of view of the contract balance, because again, since we're looking these things predominantly from the designer's perspective, if an exclusive, really wide license is given to the customer, but the customer doesn't have any obligations when it comes to IP enforcement or monitoring or renewing intellectual property registrations, for example, then that most likely is not a very balanced contract. So again, we need to look at the contract as a whole. Yeah, and as mentioned, it's important to establish who monitors and enforces rights, who's liable, and as a general rule, commercial interest should be proportionate in these examples. And then, of course, it's important to establish what is the fee, what is the license fee, and of course the compensation as well should be proportionate to the extent of the right granted. And typical examples of a license fee is a flat fee, a royalty fee, or a combination of the two, and the combination is by far the most common that I see in Ornamo's designers' contracts. And then royalty, of course, means that there is a payment that's based on success one way or another, and typically based on sales, but it doesn't necessarily need to be based on sales figures. But if and when there is a royalty piece in the contract, it's very important to pay attention to what is that royalty based on, and this is a much more important question than looking at what is the royalty percentage, because and again, this is something that should be understood very, very thoroughly. How is the royalty calculated? Typical examples are that it's based on selling price, but then it could also say that it's based on wholesale price or recommended retail price. So again, one very good thing to do is when negotiating these different sections of a license agreement, especially this pricing section, is really to go over with the customer these different terms in terms of actual numbers. So what is the customer looking at? What should be the selling price be, or the wholesale price, or the recommended retail price? Because of course the customer in this example has some kind of a target price or idea of a price. Maybe at the negotiation table we can't discuss in absolute details what the end numbers will be, but of course there are calculations and goals in mind. So again, it's good to discuss these in actual monetary numbers and not just some kind of lofty percentages based on a figure that is unclear for the designer or an outside person to really see what does this price or numeric value. What does it actually mean and entail? And one thing to avoid is any kind of mention of a net price. Because of course, if it's just mentioned as a net price, this is not a legal term that can be determined easily. So this gives, again, the licensee many times almost full control to determine what the net price will be, what is actually deducted from the price. If there is a net price mentioned in the contract, then the contract needs to very clearly determine what the net price means. So again, so that the designer or an outsider can come in and check, has this principle actually been applied when it is time to actually pay out the royalty. And there's a saying that net is nothing and gross is great. So again, keeping the numbers that the royalty is based on very clear and very simple is the best way to go. I would say that this is typically from both parties' point of view, because the less it takes to really go back and forth to try to prove how which number has been calculated is also time consuming from the licensee's point of view. So typically just good to have like a clear number that's easily you can easily check if that was the case. One option could also be that the royalties is not based on a sales price at all, but is actually based on number of produced products, for example, or number of services purchased, or this kind of volume-based number. And this can just be set out as amount, like clear amount as well, that this many euros are paid for each product manufactured, for example. And again, many other options here. Just good to understand these also in terms of money. And one thing I typically advise designers to do is have a discussion with the customer that what are your target sales prices. So let's discuss this. Like if we reach your sales target, what does that mean actually to me in euros? And the more that conversation is like, well, that depends on this and this and this, then the more problems that will probably mean in practice when it comes to the time of royalty payment. So the ideal situation is that the customer can answer that, okay, if we reach our target, that's this, that means this many euros for you in royalty payments. Yeah, one other really good tool is a minimum compensation or minimum royalty. Again, this is especially good tool when it comes to exclusive licenses. So this can be also considered as a price for exclusivity, for example. So this can be set out that there's an annual minimum royalty that the licensee has to pay the licensor, so the customer has to pay the designer, regardless of those sales targets are reached or not. And again, this is a really good tool to use for these exclusive licenses, especially because then it forces the customer to look at the situation if it makes sense to actually pay this minimum royalty every year if they're not utilizing, if they're not reaching the targets. And of course, the point here is that it's non-refundable, so the customer has to pay the minimum royalty regardless if they actually reach the targets. And this again is a good negotiation tool in the situation where the customer has very lofty targets and wants to have exclusive rights, but then especially if there's uncertainty about whether those rights will actually be utilized or if those targets are reasonable. This is also a good way to test how willing the customer is to entertain this idea. And another good thing to consider is if there should be an advance in the contract. This is especially important if there's no flat fee compensation in the contract. That again, there's an advance payment that at least will ensure some kind of compensation based on the agreement. And as we discussed in the previous section, it's important to check who decides on this pricing questions, then especially in terms of royalties if they are based on sales prices. And again, you can go into kind of quite detail into this, like whether there will be any discounts, how will that affect the royalties, if there are giveaways, should the royalty also be paid based on those and such. And typically it's good to add that if there's any additional work that's required, that's billed for separately. If there are requirements to attend customer meetings, how are those compensated? If there are travel expenses that are going to occur, for example, promoting the product or services, who will pay for those, and then other expenses that might occur in relation to the licensing deal. And then, of course, we've already discussed this term and the validity of the license. How long is the license valid? Is it fixed or is it valid for an indefinite term? And how, and so under what conditions and with what notice time can the license be terminated? These are very, very important questions. And again, this question of whether the license can be revoked or is considered irrevocable. Now these next examples, these are especially important in this example of a model that's being licensed in order to create these tangible products. So, for example, this light fixture example that we've used is to include that the license is actually used. And again, this is extremely important, especially if there's any exclusivity in the license. So, of course, in case the license is exclusive, it's very important that the customer then actually starts to utilize the license and not just hold the license, especially if the payment is only royalty based. This can happen sometimes that the designer licenses a model to the customer, and then the customer just doesn't do anything, and they have the exclusive right for a long term, and the payment is very, very emphasized on the royalty payment. So then the designer is not getting a lot of compensation for their license. So this is important in these situations to include in the license agreement. So what does it take in practice to start the manufacturing process? What does it mean? What does have to happen in order for the manufacturing phase of the project to be considered started? And what happens in the prototyping phase? Who does what? Who okays which phases? Which documents are sent, and in which form? And how do we land on the mutually accepted production model that can then actually start the main manufacturing process? And again, who approves any changes that might need to be done to the production model? And linked to this is the application to utilize the license. And again, extremely important, especially when it comes to an exclusive license. So again,
There's typically some time allowed in the contract that when you first sign the contract, that when do you actually need to start using it. So this should be addressed in the agreement. And then again, what does the use mean in practice? Is it enough that there's just some kind of marketing material that utilizes the model? Does the manufacturing process need to be started? And when do the products need to be available for order? So again, very specific questions that are good to answer in advance, and not when customer, for example, feels that they have already utilized the license because they have had some marketing materials, but nothing has really happened in the manufacturing phase. Yeah, and in link to this, again, what happens if the license is not used, and for how long? And this relates to kind of like the first commencement of the license, but also later. There is, for example, a break, a pause in the production. How long then can that go for before then the license is actually considered expired? And again, the minimum royalty is a somewhat good tool to use, especially in relationship with an exclusive license. Then marketing and reference rights are also important to include in a license agreement. And so this means how to indicate the designer, their name or brand, for example. So this can just mean really, again, practical things. Where does the designer's name, where should it be mentioned? Does it need to be in the packaging? Is it okay if it's just on the web page? And if there are any other kind of promotion in relationship to this? Again, unfortunately, typical situation in a design field is that the customer likes to offer some kind of promotional value for the designer, but of course, then it needs to be very clearly determined. What does that mean? What does that mean in practice? And that should, as a general rule, that shouldn't be the main compensation form of the contract. Of course, there are always exceptions, but this is an unfortunate typical situation where the customer just likes to offer visibility and promotion to the designer. A couple other questions. Does the designer receive product samples? And it's important for the designer, the licensor, to remain the reference right. So this is especially important again if there's an exclusive license given to the customer, because then it's not clear that the designer can even showcase this model as a reference in their work. So it's again best to clearly state this in the contract, that how can they use this as a reference as part of their portfolio. And this same applies for example, these IP transfer situations. And again, there's usually a mention of the right to receive materials from the customer or the licensee to be used as a reference in the portfolio. So this could mean marketing pictures, for example, that might be owned by the customer, but again, then the customer actually grants the designer the right to use them in their portfolio and other promotional purposes. And there might be some mentions about whether there's an obligation or right to participate in promotional activities and what a compensation for those would be. Now, especially if the license fee is based on royalty, it's important to mention how that royalty payments, how often they're paid, and also what will the royalty report include, and also include the designer's right to check if these are correct. So have these audit rights, and good to remember that audit right might not mean just accounts, but could also relate to manufacturing processes, for example. So again, there could be conditions specifically related to sustainability, for example, that could and should be checked from time to time if those are actually being applied the way the contract says they should be. And then there's typically a mention that in case there's some discrepancy or too big of a discrepancy between the reports and what is found in the audit, then the licensee, so the customer, has to then pay for the audit. And we're getting towards the end of these terms. Couple more coming up, so I will kind of quickly go through these, and these materials will also be downloadable in our webpage later, so you can visit these later on. But it's important to state in the contract what will happen when the agreement is terminated. So exactly what happens in what time. Are there any rights that are valid for some period of time, and what kind of will be the absolute end date of the license validity, and whether there are obligations of the licensee to return materials, destroy any molds that might have been used to make the products. Maybe the designer has the right to purchase those with a reasonable price, and that would be good to again determine in advance what does that mean in practical terms, and be aware of this kind of pump and dump possibility that some contracts might allow, where kind of when the contract has been terminated, the customer, the licensee, could really manufacture a lot of products that they then can later on sell in a very inexpensive price. And for example, if you're changing your licensee, that could interfere with the next customer if there's a lot of those products very, very cheaply available in the market. Limitation of liability is a clause that's found in most contracts. It typically excludes any damage payments in relationship to indirect or consequential damages. And it's also, again, from the designer's perspective, the designer might be liable for any damages that it's capped on a monetary number, or could be kind of like stated that it's capped at the flat fee that the designer receives according to the contract. Most typically, these type of limitation of liability clauses do not apply in case somebody has caused damage intentionally or by gross negligence. All right, couple words still about intellectual property rights in these license agreements. So of course, intellectual property rights are at the heart of license agreements, since it's an intangible assets that are being granted access to. But it's again good to check how are intellectual property rights defined in the agreement, because this can have a very specific contract specific definition. And then if there are different categories of intangible assets, how is it stated who owns what, and also how is the ownership to these verified? If all the contractual transfers are in order, and making sure that the design process is intact in the sense that if there's any co-design features here that the intellectual property rights have been kind of secured in all those different phases. And then when especially bringing a new product to a market, it's good to realize that there will always be some kind of market research, and especially when it comes to checking out if there are similar products or services out there, especially from the point of view of possible IP infringements. Who is responsible for conducting those, and then in case the design in this situation is not registered at the time of the licensing agreement is being negotiated, if it's a new design that will only be registered as kind of part of this process, then whose name is the right being registered, and this does not mean that it needs to be the same person who handles the registration process, for example, or pays for the registration process. So all of these different things should be determined in the contract. And again, making these decisions about in which countries the design right, for example, is registered. But again, if the design already is registered at the time of license, then these aren't so relevant questions. Then it's very important to check what the license agreement says about IP infringements. We're not going to go too much into detail of this today. We will discuss this in the next section. So when in 2 weeks when we have the webinar about IP infringements. But since this is a very important part of a license agreement, I include these slides here as part of this presentation. But we will discuss these in further detail in the next section. Again, there's typically a warranties and representation clause in the contract. And what does this mean in practice? What does this section entail? Well, typically it says a kind of states that both parties have the power to execute and deliver the actions in the agreement and have made appropriate representations about, for example, their ownership of different rights. And then there's typically some kind of assurances about certain aspects of the contract made. So there could be assurances about the validity, ownership of intellectual property rights. Sometimes there are mentions about that there are no IP infringements, which again, from the licensors or the designer's point of view, can be problematic. So then the kind of maximum would be to kind of cap this to the best of their knowledge, not being aware of these kind of IP claims to have been made. But then also the warranties and representation part typically also limits the scope of liability for IP infringements. For example, there's typically a disclaimer that the design will fit a certain particular purpose or that it will be a commercial success. So these are typically waived with these warranties and representations, and that there are no kind of implied warranties. Now, this is one of the last pieces of this contract that I want to go over here. An indemnity clause it can be found in license agreements nowadays. So what does this mean? So in practice, an indemnity clause, this whole indemnity clause is typically found in or kind of stems from U.S. contracts. So especially if you're making contracts with a U.S. customer, these are more typical. But also in Europe nowadays and in other countries, you see more and more of these indemnity clauses, and these are kind of possibly dangerous clauses. So again, if you see an indemnity clause in a contract, it's good to pause there and go over with a lawyer or an expert. What does this mean in practice? What kind of risks am I actually taking on me if I agree under this indemnity clause? So in practice, an indemnity clause means when does one party have to compensate the other party for certain losses or legal claims, and especially because of these legal claims or fees, these possible losses can be very, very, very high, and are typically in no proportion to the compensation that's being paid in accordance with the contract. And very typically include broad definitions of an IP breach, for example, that a designer has to pay for, and including all the legal fees, and again, is in no way compensated in the flat fee or royalty payments made to the designer. And again, of course, it's good to evaluate whether the risk is in balance with the ability to even control these questions. So again, if we're talking about design, it's impossible to say that there is not a design in one market, let alone in global markets, that's close or gives a similar overall impression than the design that we have made. So this is something that designers should be very, very aware of, and not sign these indemnity clauses without very careful consideration. And typically we advise designers to assure the customers that they have created the design themselves independently, and can prove this. So they have documented their design process well enough, but cannot give any warranties, assurances, or sign any indemnity clauses, whether there will be a product that's somebody else considers to be too close, and possibly that the design is infringing on their rights. And in case any of these indemnity clauses are agreed upon, again, I very much advise to go over this with an advisor who understands these questions, and then making sure that the this kind of assurance is very, very limited and very clearly determined, and that there are clear obligations for then the customer of notification, cooperation, and also that the commercial interest of different parties again is in proportion of these risks and liabilities that they carry under this agreement. That was the last part of the contract part. We've already discussed a couple of these, or mentioned many of these, like kind of ways to negotiate a license, and let's look at that for a couple more minutes before we will have time for a free discussion. So we discussed this a little bit previously, but typically the first negotiation point in a license agreement between customers and designers is whether there even will be a license agreement, or if there will be an IP transfer instead. And as mentioned before, this negotiations are best started by understanding what each party is looking to achieve with the contract, and an exclusive license can give the licensee rights that are very, very close, if not almost identical to an IP transfer. So this is again something that I've heard many times, that the customer needs to have an IP transfer because they need to make some modifications. Again, you can easily do that with a license as well. You don't even need an exclusive license for that. So again, it's good to kind of understand what is the customer looking to get, and of course also understand from both parties' point of view what are the options here. If we're talking about a light fixture, for example, that we've used in these lectures in this webinar and in the previous ones, it's very easy to understand that same product can be licensed to many different customers who can have use for that. But maybe the customer or the product is so customer specific that there's not really much use for other customers, then we're getting again closer to a broader exclusive license or possibly even the IP transfer. Again, good to understand what is the product or service that utilizes the license, and what are the needs of different parties. This is the first starting point for the negotiations. If both parties understand what the difference of a license and transfer is, and as mentioned many times, I've heard from the customer perspective these reasons for an IP transfer that do not actually require an IP transfer, but can be achieved with a license just as easily. From the designer's perspective, a license agreement almost always is more advantageous because even if the license is given very broadly, very broad exclusive rights, the designer still remains as the owner. And like I mentioned before, even if it just happens so that all of the rights have been licensed with an exclusive license to the customer, but only in the situation where the customer goes bankrupt, all the rights are fully returned to the designer. These things happen, and I've seen this many times where in a couple of decades this could be a very, very relevant question, even if when negotiating these things, it of course nobody makes these deals thinking that they will be bankrupt soon, but these things happen. So usually is recommended for designers to utilize this license agreement. But of course, it's good to understand that when you are the right owner then of an intangible property, intellectual property, it is maybe required to understand a bit better about intellectual property rights. But it also typically allows for stronger long-term success. And as mentioned, licensing allows for very broad grant of rights. So there are many options between a non-exclusive license and a full IP transfer. And of course, it's always the question whether the compensation is proportionate. And one reason that I've heard from customers of designers many times is that they want the full IP transfer because they want the design, for example, to be part of their intangible property, so that they can possibly sell it, or again, if something would happen, they could show that as their property, or even in a bankruptcy sell that, which is very true. It's a valid point, but then this kind of comes back to compensation, that it then most definitely should be also appropriately compensated. And a couple of things to remember in case the IP transfer is used is that doesn't mean that there has to be a one-time fee. A royalty can also be used in IP transfers. It's good to be aware of any IP liabilities that might be left on the designer in these situations. So even if all the rights are given, in worse situations, there's still a lot of IP liability left on the designer, and again, this typically is not balanced contract. So this is something that's important to be aware of. And again, as we discussed, these reference rights and right to be mentioned as the designer, even if you have transferred all of the IP rights to customer. This is still important to remain this right. And then, as I think I have this, and then one more slide left on this presentation. So a couple pointers about negotiating licensing agreements. So with any negotiation, it's always best to start with negotiation freedom. So the ability to also walk away from the deal that's being negotiated. Typically, the hardest situations are ones where both parties have already made investments. They've already made many actions based on the upcoming license agreement. But then, in case that is never actually agreed upon, then you face the difficult question of like, will there be any compensation from one party to another? So again, this is the best time to have these negotiations is early on when there's kind of freedom to decide whether you will actually sign this contract or not. And as mentioned, with license agreements, just as with all agreements, the best results are obtained when you understand what your own goals are and what your customers' partners' goals are. And again, we are discussing in this presentation a lot about these negotiations in perspective of customer demanding this and designer demanding something else. But of course, these contracts are made ideally and most typically because the contract parties are actually forming some kind of partnership, and so it's many times, especially when contract negotiations kind of start to get heated and there starts to be many sections of the agreement that the parties disagree about. It is good to pause and remember that what is the goal here? We're creating a partnership where we actually have more interests that are aligned than the ones that differ. So it's good to keep this in mind, of course, in the beginning and throughout the negotiations. And of course, if this is not the case, then it's might not be the best person to enter into this contract with. Yes, and so this is something we've discussed already, that these are the typical or a typical negotiation part is this exclusive or non-exclusive license, and one option is to actually create different pricing options for different broadness of a license. So an exclusive broad license will cost significantly more than a more strictly defined one or a non-exclusive one. And as mentioned, this minimum royalty payment, it's a very useful tool that actually can make the processes much more simple. So maybe not so much reporting, or some of the reporting responsibilities can be just can be left out, and also forces the customer to really think, are we actually utilizing this license if there's a minimum royalty payment? So then the designer doesn't have to be so aware of these situations where the customer just holds the license but doesn't utilize it. And yeah, as mentioned, these warranties, representations, and indemnity clauses, pay attention to these sections. They're typically in the latter sections of the contract. And as even with this webinar, as you go, you've gone through many sections of the contract and you start to feel tired and weary. It's kind of easy to just go quickly past these, but don't do that, but pay attention to what do these, because they can include hidden risks that can be very, very costly. And as with all contracts, make sure that the risk is proportionate with the compensation and the control rights. So if you do not have control over some things, you shouldn't be liable on those questions either. This is just a reminder of these exclusivity things. And then last reminders is that when registering intellectual property rights, EUIPO has this SME fund that actually gives monetary support, financial support to small and medium-sized enterprises, and the time on that and also the funds are running out. So make sure that you apply. You can use that for an IP scan to figure out what rights you have. You could register, or if there are any registered rights in the market that are similar. And you can use that for expert fees, so design, trademark, attorney fees, for example, and also use that for the registration fees themselves. And as mentioned, in 2 weeks and 4 weeks, we're continuing on this webinar series. Next time, discussing these IP infringements in an online environment. But that is it, and now we have some time left for questions, discussion.
One question.
Part. Yes. Okay. Let me check.
You can stop the sharing.
Yes. Yes, I can stop the sharing and then go to the chat section.
Yes.
If somebody would like to actually ask these questions themselves, you can do that.
Yes. I have a question. What are the minimum royalty fees?
Yes. So a minimum royalty fee would mean that if the compensation of the contract is based on royalty payments, so a percentage of sales price most typically, but it could be stated in the license agreement that there is a minimum fee. So that could be just a monetary sum that's paid by the licensee, so the customer, to the licensor, so the designer in this example, regardless of whether those sales are actually achieved or not. And as I mentioned, this is especially useful in these exclusive license situations. So if the customer wants to have exclusive right to utilize the design, for example, and they, of course, from the designer's perspective, this means that I can't license this to any other customers. So I'm totally dependent on the sales of this one customer. So it can be considered that it is part of the licensing fee. So, for example, annually the customer has to pay a certain amount, and it is considered to be a royalty payment. So, in case the sales figures are higher, the customer would have to pay in accordance with this percentage, which is the typical royalty fee. So the royalty could just be set out to be 7% of the sales price. For example, this is a totally one example. So in case the customer sells really well, it's based on that 7% of sales. But then there's a monetary amount. Let's say, again, I'm just throwing figures here. Let's say that's 12,000. So that 12,000 is paid annually, even if it doesn't make up for 7%. So that's what it means in practice. And again, especially useful in terms of exclusive license, because you can then negotiate this with your customer, that if you're so confident that you will make these sales figures, that's fine, but there's a fee related to it. And again, if you're less confident, then maybe the license should be non-exclusive, so some other customer can also utilize the license. So again, it's something that can be used in the negotiations.
It's clear.
Yes.
Because sometimes you don't want to have the stamp of the manufacturer on the products, but your own stamp. You just buy and sell instead of making a license agreement, because sometimes it's really lousy.
Yes. So that's
the results are almost nothing after 1 year.
Exactly. And this is where the minimum fee could be a useful tool. But this question, whether you kind of create your own product line, and then you actually just make these resale agreements or sell your own products, or you license this to a customer. This is, of course, a question of how, as a designer, how do you want to work? What's your form of operation in that sense?
Thank you. That's clear.
Yes. Thanks. Let's see.
Bureau.
Yeah. Determine the amount of royalty. Yeah, there's a question about the percentage of royalty, percentage or combination of flat fee and royalty. As a general rule, I would just say that we recommend typically this combination, because it also shares the risks a little bit. So if the payment is fully based on royalty, again, especially in relationship to an exclusive license, that can be quite risky. So we recommend the combination. What should the percentage be? Again, the first question should always be, what is the royalty based on? Then what percentage? This is not something that I can really answer. This is depends on the fields and many other questions. Also, as an organization, we cannot give figures, because that could be considered determining prices. So that's not anything I can really answer. Of course, there are sometimes research conducted that gives some implication, but again, many times in many surveys, when it's asked like what kind of percentage are you getting as a royalty, it fails to ask what is it based on. So then it's not really so relevant information. But this is maybe more something that I think as designers could be shared between designers in that same field, to kind of have an understanding of what the market prices are. Many times designers are kind of alone in these situations, and I've seen this, that it's difficult to set out these prices, and that's why, again, I highly recommend just putting these into numbers. That, okay, well, what does that percentage mean in euros if we're talking about this much sales or that much sales? And many times that actually, like, even possibly for the customer, shows like, okay, well, that's not very much money. Even if we reach the target, that the royalty payment is quite low, and then should most likely be renegotiated.
One question. Can Ornamo help finding licensees in Finland and in the Nordic countries?
Well, we don't do that directly. Yeah, we don't directly do that. We do have in Ornamo, we have this platform called Finnish Designers that does help to bring different actors together. And so indirectly, yes, but as actively as people working here, we don't do that. But yeah,
I'm a Finnish national, so I would like to be a member of the Finnish Designers.
Yeah, for sure.
Yeah, I can explain you later what is it about. It's quite interesting.
Yeah, I think we can have in the chat as well information about how to join Ornamo as well. We don't have a requirement that you have to be Finnish nationality or necessarily even work in Finland. Of course, there's typically a link to Finland in order to want to be a member of Ornamo. Our most important requirement is kind of professional designers. So that's the part that we're the strictest of. There's the professional part. All right, let me check. There were a couple other questions in the chat. There was a question about how the audit is implemented. Well, again, depends on what kind of audit. If it's accounting audit, then it's determined in the contract that you have the right to request bookkeeping and typically even assign somebody else to to actually go through accounts and the bookkeeping of the company to check that, for example, the sales figures actually are what the customer has reported them to be, and if it's in relationship to a manufacturing process, then it could just mean that having the right to check, actually physically go to the manufacturer with 2 days notice or something could be stated in the contract. There's a question of how does the license contract with the reseller only differ from the contract with the manufacturer? Also in the role of a reseller. The reseller is found among the manufacturers. Old client, how is it wise to develop a contract between 3 different parties, designer, licensor, product manufacturer, and reseller? Yeah, okay, this is quite broad question. Yeah, so if I understand correctly from this question, so first there's kind of the differentiation of manufacturing and reselling. Well, of course, there are templates for just manufacturing agreements and reselling agreements. From the point of view of licensing that we're discussing today, of course, the difference there is that what is the actual grant of license. So in a manufacturing contract, it would very specifically mention the right to manufacture, but nothing else. And in terms of a reseller, it would state the right to possibly bring to market, but sell and offer for sale type of activities. And then there's a question if the reseller is found among the manufacturer's all clients, how is it wise to develop a contract between the 3 parties? Yeah, 3-party contracts can be tricky. Sometimes they are necessary to really understand a full project or full scope of business activities. It can be tricky from the point of view of understanding who's responsible for what pieces. So sometimes they can be kind of chained. So there's just 2-party agreements, but then there could be these sub-licensing rights granted. Yeah, maybe if there's a specific situation in mind here, it might be something that could be discussed in Ornamo's member advising if you're a member of Ornamo. Yeah. Yeah, then there's another question about what should determine the amount of I think the percentage of the royalty. Yeah, again, typically we recommend the combination of flat fee and royalty, but of course these vary case by case. That's the most important part here. Is to really understand the contract as a whole, and any kind of specific part is hard to understand on its own. So yes, some examples of why would be 3%, 7%, 15% royalty. Again, this I would say that check first what is the royalty based on. So again, if it is typically you see this that there's a net price with a high royalty percentage. So it can be even like 20-30% of based on a net price, but then when you check how is the net price calculated, you realize that the actual amount that you get, even if the percentage was high, is actually very low, or is totally controlled by the customer, meaning that they can add in costs that you have no way of controlling whether those costs are put there or not. And again, just making the contract imbalanced in the sense that there are things that are out of your control that will affect the fee. So that's why we always recommend that make sure first that the royalty is based on a very clear number, or can also be, as mentioned, something else than a sales price. Could be production or manufacturing units. Then there's a question if I can have access to customers' accounting to check the numbers behind royalty, although it's not agreed with the customer in the contract. This is a trickier question. Again, best to have this in the contract. The contract is the first place to have this set out as an obligation. Now, this would become more of a question of national legislation. If there's national legislation that would allow for some kind of rights. So in a general rule, I cannot say. It could require quite hefty, costly measures as well. For example, trying to get a court, for example, to it could be like ordered in a court order that the other person has to show account numbers, for example. But again, to get there would require quite a bit of resources. Yeah, so if Ornamo provides some statistics or other examples, the proportion of royalties, we have some of these in some of our surveys that we provide. These can be found in our webpage, and of course some of these things are kind of our member benefits, that some of the survey results that we ask our members are also only shared with our members. We have done some surveys, but as I mentioned, sometimes the problem with asking royalty payments is the fact that it's still unclear what is that royalty payment based on, and I will just mention this again, that it's very important to understand in numbers. So this is something I encourage designers to do, is to calculate. So what is the royalty percentage? What would this mean in practice with different forecasts of sales figures, for example, because the customer most likely will have some kind of forecasts and some kind of targets for sales. So you can discuss this with the customer. What would this actually mean in monetary terms? Many times I've seen this, and then the number is that you will get 300 euros in case this is a real hit, in which case you realize that there's no proportionate compensation in the contract. So this is why it's important to also not just think about these as percentages, but actual numbers. We are now we have reached the end of this time. So I would like to thank everybody for participating. It's been quite a lot of information in 2 hours. Please feel free to revisit the recording, and also, as I mentioned, we will have this presentation available at our webpage, so you can retrieve that from there as well. Again, I would remind everybody to please answer an very short form feedback questionnaire that you will get into your email. So not just the Zoom one to just ask about how the Zoom was, but an email that we will send from Ornamo to you. The results are very important for us to show EUIPO, who is the funder behind this project, and this helps us hopefully procure in the future also these this type of trainings and content that's specifically modified for designers and based on designers' needs. So it's actually very helpful for us to receive, especially the good feedback. So thank you, everyone. I can see from the chat some messages, and thank you likewise. I know myself there was a lot of information here, and again, especially as Ornamo's members, you can book a session with lawyer to go over your specific question, and I also advise others to reach out their organizations or other advisors that can help them in your specific situation. But thank you, everyone. This concludes this webinar, and hopefully see you in 2 weeks when we discuss IP infringements.
Thank you.
Thank you.
Thank you.
Bye.
Thank you.